We understand Mr. Smith was shot several times. Does he wonder why he's still living?
My husband had been shot, and they took him to Houston Northwest. He didn't make it.
Quentin Smith opened fire.
So that's why I started.
During a heated admonishment, Fulton County Superior Court Judge Alfred Dempsey sternly addressed defendant Tyler Grogan.
You at police, you violated that woman, and you don't want to hear it. Well, you're going to hear it, and I don't give a rat's behind whether you like it or not.
On Wednesday, a jury convicted a man from Roswell of nearly 30 charges related to a May 2011 standoff at the Aspen Point Apartments. Prosecutors stated that the man robbed 2 individuals at the location, then held them hostage for hours, during which he repeatedly assaulted a woman as SWAT teams surrounded the area. As Judge Dempsey prepared to sentence him, the judge used strong language.
Sit him down. Given the defendant's actions, I got a different sentence I'm going to impose now.
The judge sentenced the defendant to 7 consecutive life sentences, plus an additional 270 years in prison. His attorney conveyed to the court that Grogan regretted his actions and attributed his behavior to personal demons stemming from the murder of his own mother a few years earlier.
Life had just been too much for him. He put himself in a situation which he did, and it began to get out of hand.
Outside the courtroom, tensions flared as supporters of Grogan became unruly, directing curses toward the police, the judge, and the district attorney for the severe sentence. This is David Ranta. He spent 22 years in prison for a murder he didn't commit. In Brooklyn, New York, Ranta was arrested by Detective Louis Scarcella and put in a police lineup run by Scarcella, where he was identified as the shooter. However, decades later, the key witness reportedly revealed that the detective had provided him with a description of who to pick in the lineup. There was no physical evidence linking Ranta to the killing, and the evidence presented to the jury was allegedly fabricated. Ranta was convicted and sentenced to 37.5 years to life in prison. After spending over 2 decades behind bars, former witnesses admitted they were pressured into testifying against Ranta, and now his conviction is being overturned.
Mr. Ranta, to say that I'm sorry for what you have endured would be an understatement and grossly inadequate, but I say it to you anyway. The defendant's motion to vacate the judgment of conviction is granted.
After his handcuffs were removed, he embraced his family. Carrying all he owned over his back, he walked out a free man. Following his release, he reportedly received $2 million from the state and a $6.4 million settlement from the city of New York. This is Kimberly Long, who was wrongfully sentenced to 15 years to life in prison for a murder she didn't commit in Riverside, California. Long returned home to find her boyfriend dead and promptly called 911. Despite being the one who discovered the body, she was soon deemed the lead suspect. Long was later convicted of second-degree murder and imprisoned. However, 7 years later, forensic evidence revealed that her boyfriend had died long before she arrived at the scene, and DNA belonging to an unknown male was found at the crime scene. As a result, her conviction has been overturned.
The judgment of conviction is vacated and a new trial will be ordered.
Long is now a free woman, having been released from prison after her wrongful conviction was overturned. The prosecution quickly dropped all charges against Long, acknowledging the injustice she had endured.
I feel happy, elated, relieved, just a lot of emotions right now.
Long reportedly received $386,000 from the California Victim Compensation Fund to help her rebuild her life after her wrongful imprisonment. Jesse Michael Gomez, 58, was sentenced to death after being convicted of murdering San Diego police officer Jonathan J.D. de Guzman, 43, on July 28, 2016. Gomez was found guilty of the special circumstance allegation of killing a police officer, as well as the attempted murder of Officer Wade Irwin, de Guzman's partner, and being a felon in possession of a firearm. De Guzman, a 16-year veteran of the San Diego Police Department, tragically passed away at the hospital, while Irwin was hospitalized for nearly a month due to a gunshot wound to the throat. Gomez, who testified in his own defense, claimed that he did not realize the men approaching him on Acacia Grove Way that night were law enforcement officers, and believed they were gang members intending to harm him.
Tell me what you did see.
My eyes were not fully adjusted for when the lights turn on, so that's why I started.
This shooting happened. Did you see anything like that?
I did not.
At Gomez's sentencing hearing, his defense team argued that the death penalty should be eliminated in his case, partly because Gomez was a victim of racism and bias. However, San Diego Superior Court Judge Frederick Link disagreed and upheld the jury's recommendation of the death penalty. He also rejected the argument that Gomez did not realize he was shooting at officers, stating, "For anyone to say Mr. Gomez didn't know what was going on is ridiculous." Gomez expressed genuine remorse for the incident, but maintained his account of how the shooting unfolded.
If I could trade places with Officer Guzman, I would, but I cannot. And I am truly sorry for that. I just want to let the Guzman family to know that this was not an intentional act. And the second thing is that I told the truth on what happened that night. That's all I have to say about that.
Verdict, count 1. People of the state of California, plaintiff versus Jesse Michael Gomez, defendant. We, the jury, in the above entitled cause, fix the penalty for count 1 of the information. Now that the case is over, you may choose whether or not to discuss the case.
Shay Groves, 27, was found guilty at Winchester Crown Court of murdering her on-again, off-again partner, Frankie Fitzgerald. Groves stabbed Fitzgerald 17 times in the chest and cut his neck at her house in Havant, Hampshire, in July of last year, all while pretending to be the victim herself. During the 5-week trial, it was revealed that Groves had decorated her walls with images of serial murderers, collected books on criminals like Charles Manson, and regularly watched real crime documentaries. Prosecutor Stephen Perry and Casey told the judge that Groves acted out of jealousy upon discovering that Fitzgerald was messaging a 13-year-old girl on Facebook. He stated, "The murder of Frankie Fitzgerald is very likely to be a crime of passion, motivated by her jealousy." Perrion also claimed that Groves used her knowledge from true crime programs to portray herself as a victim of Fitzgerald's sexual aggression toward her friend, Vicky Batup.
We are pleased with the jury's verdict, and the sentence will ensure that Groves spends a significant period of time in prison for what she has done. Nothing can fill the void that has been left in the lives of those who knew Frankie, and our thoughts remain with his family, friends, and loved ones.
The prosecution argued that the defendant was well-versed in crime scenes, fabricating false narratives and establishing fake alibis by studying murder documentaries. They claimed that Groves intentionally crafted a false narrative of being abused by Frankie Fitzgerald, which she then relayed as a false alibi to Vicky Batup. Additionally, Groves was found cleaning the crime scene after watching these documentaries. Furthermore, it was revealed after her conviction that Groves had been involved in distributing cannabis. Judge Kerr addressed the jury, expressing gratitude on behalf of the court for their dedication and hard work on the case. Sarah Boone, a Florida woman accused of concealing her lover in a suitcase and abandoning him to die in 2020, appeared before an Orange County court for a preliminary hearing.
I'm sorry, the defense is not ready. We're requesting a continuance. We are having difficult time finding an expert who is willing to work for the JAC rates. And so I'm still, and to be honest with you, this case has had so much notoriety that people don't want to be involved.
Okay. Judge Wooden granted the continuance and scheduled a new pre-trial hearing on July 11th. Boone has been charged with second-degree murder in the killing of George Torres Jr., 42. On February 25, 2020, Orange County deputies arrested Boone, then 42, after investigators alleged that Torres Jr. died after being zipped inside a bag and left there for hours. The incident reportedly occurred at the couple's Winter Park home on Aloma Avenue and Goldenrod Road. Boone told detectives that she and Torres had been drinking wine and playing hide-and-seek when she went upstairs and dozed off in her bed. She said she awoke hours later to her cell phone ringing repeatedly. Allegedly, she then noticed her partner was still inside the luggage, and when she opened it, she discovered Torres was unconscious and not breathing. Deputies arrived to find Torres dead after Boone called 911. Prosecutors revealed that 2 videos on Boone's phone depicted her recording footage as her partner attempted to escape from the luggage. In the first video, which began filming on February 24, 2020, at 11:12 p.m., Torres could be heard continuously calling out Boone's name. According to authorities, she appeared to be smiling as he screamed in fear, pleading for help until his last breath. In the video, Boone could allegedly be heard shouting insults at Torres, including, "F you for everything you've done to me," and "Stupid, that's your fault." She reportedly continued, "Oh, that's how I feel when you cheat on me." In the second video, which began filming on February 24th at 8:20 p.m., Torres could be heard calling out Boone's name, according to police. The arrest report stated that the luggage was in a different location in the second video. Prior to the tragic incident, Boone and Torres had a history of domestic violence, as documented in court records. They were both previously arrested in Orange County for violence against each other. Karen Stewart, 51, was arrested on a murder charge after allegedly confessing to the murder of James Hargrove, whom she described as her husband, when he brought home another woman and expressed his love for her. The incident took place shortly after 2:20 a.m. on Saturday at a residence in the 600 block of Buttress Route Drive in the city of Spring. Constables from Harris County Precinct 4 responded to the scene and found Hargrove with multiple gunshot wounds.
My husband had been and they took him to Houston Northwest. He didn't make it.
Stewart informed the police that Hargrove was her husband and admitted to firing shots at him in a jealous rage after he confessed his love for another woman. Hargrove's 41-year-old partner was present during the shooting, but managed to escape without injury. However, she has not been identified. During Stewart's initial court appearance, a woman named Sandra Hargrove came forward and told several local news outlets that she was James Hargrove's true wife, not Stewart. Sandra claims that she and James were married in 2009, but later divorced. Despite their breakup, she asserts that they remained best friends, spoke daily, and even discussed the possibility of reconciling. "He's still my husband," Hargrove said tearfully. "I mean, we have grandchildren, children, nieces, and nephews. That remains my husband." Sandra stated that she had no idea James, who had various health concerns, was involved romantically with Stewart, let alone another woman. Sheriff's deputies revealed that James and Stewart had been in a relationship for 7 years and had lived together on and off. James's other girlfriend, who witnessed the shooting and fled for her safety, informed police that she believed James and Stewart were in an open relationship and that he wanted the 2 women to meet. According to his wife Sandra, James had recently recovered from COVID after being in a coma for 4 months. Prior to that, he had spent a year disabled after experiencing 2 heart attacks, a stroke, and renal failure. Stewart remains in custody on a $75,000 bond. This is Quentin Smith, who is facing charges for multiple murders in Ohio. Smith is currently on trial in Franklin County Common Pleas Court for the devastating murders of 2 Westerville police officers, Eric Joring and Anthony Morelli. The officers tragically lost their lives while responding to a domestic violence incident in February 2018. The case deeply shook the community. Motivated by jealousy, Smith violently attacked his wife, Candace. When the officers arrived at the scene in response to a distress call, Smith senselessly took their lives while they were fulfilling their duty.
Anthony Morelli and Eric Joring walked through the front door of this Westerville townhouse Saturday afternoon. Columbus Police Department contacts tell me Quentin Smith opened fire.
As if the murders weren't tragic enough, Smith's behavior in court added to the heartbreak. Throughout the trial, the courtroom was filled with emotion. The judge read an email from the grieving Joring family, whose powerful words resonated as they shared their deep pain and loss. They even expressed a belief that God spared Smith's life to give him an opportunity to repent for his heinous crime.
Share a little bit from the Joring family email to me. They said, "We understand Mr. Smith was shot several times. Does he wonder why he's still living? We fully believe God spared him that day to give him time to repent for this awful crime. His repentance is honest and truthful. God will forgive him and welcome him into heaven."
Fellow officers also testified in court.
And I couldn't do anything for him. Officer Morelli was young and he was hit, so I moved over to him real quick.
Morelli was laying on the floor, holding himself up by his elbow. He looked up at it.
The jury had the weighty task of determining whether Smith should face the death penalty. However, after much deliberation, they couldn't reach a unanimous decision. Judge Richard Fry stepped in, sparing Smith's life, but justice was still served. Judge Fry sentenced him to 2 life sentences without the possibility of parole and an additional 26.5 years behind bars. Despite the sentencing, Smith maintained his icy demeanor, choosing to remain silent without offering any words of apology or remorse. Smith's icy conduct suggested his guilt. Grace Elizabeth Coleman, a 23-year-old California woman, was sentenced to at least 21 years in jail for a drunken hit-and-run incident that claimed the lives of a young couple and their 3 young daughters as they were admiring Christmas lights in Newport Beach. Coleman was driving under the influence, which resulted in the tragic accident. She publicly accepted full responsibility for the devastating incident before the judge. Coleman pleaded guilty to causing the death of Henry Eduardo Selena Mejia, 27, and his wife Gabriela Andrade, 28. The couple's daughters were also injured in the incident and taken to the hospital. According to Santa Ana police, the collision resulted in all of their legs being fractured, and one of the children suffered 2 broken arms. Coleman's blood alcohol level was 0.22%, nearly 3 times the legal limit, when she struck the family's Nissan Versa at the junction of Newport Coast Drive and Pelican Hills Road South, according to officials. It is believed that Coleman may have run a red light as the family approached Pelican Hills, according to Newport police. A judge sentenced Grace Elizabeth Coleman for her actions. During the hearing, 2 of the orphan daughters read letters they had written to their parents, which the family's lawyer described as perhaps the most emotional thing I have ever witnessed. Coleman had to wear a mask during the hearing, which hid most of her expression. However, an attorney stated that he did retain her concentration on all the speakers, which I felt was acceptable. This is simply another example of a drunk driver damaging several lives, including her own and then the people around her, he added. Even though she was wearing a mask, it was very evident that she was crying and could not stop thinking about what she had done. She was so shocked that she didn't even say anything during the hearing. However, she did speak privately with the family of Henry and his wife Gabriela in a rare meeting arranged in a courthouse. This meeting was very private and was not attended by defense lawyers, prosecutors, or even a judge, an attorney explained. They felt she was truly sorry. They felt she had made a terrible decision. They're not angry, remarked the attorney. However, the victim's attorney filed a negligence lawsuit against Coleman and her parents, James and Kelly Coleman of Newport Beach. He blames her parents for enabling her to continue driving the 2010 Land Rover they had given her, despite 2 drunken driving incidents. In 2017, Amber Pereira of Tampa Bay was involved in a fiery collision on the Selman Expressway. Pereira, according to investigators, was intoxicated when she caused a chain reaction that claimed the lives of 3 members of the Felipak family. Pereira was driving along the Selman motorway when she collided with Luis Felipak, his wife Rita, and their 8-year-old daughter Georgia. Pereira lost control of her vehicle, which collided with Felipak's vehicle, sending it into the westbound lanes where it was struck by 2 other vehicles and caught fire. According According to police, Pereira continued driving and was detained later when her car couldn't proceed any further due to the damage. She pleaded guilty to driving under the influence following the horrific wrong-way incident. Initially, Pereira claimed that she had a seizure, but she was subsequently charged with DUI manslaughter, DUI with serious bodily damage, fleeing the scene of a fatal collision, and evidence destruction. Investigators revealed that she had been drinking and driving at speeds of more than 100 miles per hour before the incident. According to evidence, additional testing found Pereira had 3 cannabis-related chemicals in her system, 2 of which were in amounts high enough to affect Pereira's brain. As soon as the judge announced her 50-year life sentence, she could not stop crying. Pereira wiped away tears moments before Circuit Judge Christopher Sabella sentenced her to 5 decades in prison for triggering a catastrophic collision. The judge made a brief reference to a prison conversation captured after Pereira's arrest, which was aired in court by prosecutors. In the conversation, Pereira told a family member, "My life is wrecked." "Your life is wrecked, ma'am," Sabella said, "but you also ruined a lot of other lives and ended 3 lives. The judge continued, "Miss Pereira, you tried to run until your automobile wouldn't let you, and to the degree that that seizure had been attempted to explain, you proceeded to evade any responsibility for this crime at the hospital when you tried to conceal the tubes of blood that had been seized from you." Her attorney began to discuss sentencing guidelines, suggesting a minimum of 35 years in prison as she sobbed. He requested the court to overlook these recommendations and instead sentence his client to 20 years in prison. He argued that her criminal history was minimal and that she had no intention of causing harm to anyone. Despite his plea, she was still sentenced to 50 years in prison. This is the case of Keenan Ivory. On November 16, 2014, at Papadon's Pub in Akron, Ohio, Keenan tragically took the life of Officer Justin Weinbriner. Upon discovering Justin's body, the police identified Keenan as the perpetrator of this horrific act and later decided to press charges against him. Losing a loved one is an incredibly challenging experience for any family member. However, for Justin's family members, this nightmare became a heartbreaking reality. One of the family members expressed their emotions during their testimony before the jury.
Good morning.
Good morning.
For several weeks now, we've sat in the back of the courtroom and said nothing. Today is our turn to speak. I speak for Justin and his mother, who are joined in heaven and watch down on us, his grandparents, his daughter Charlie, her mother Elise, his sister Kelly, his fiancée Tiffany, his cousins, his aunts and uncles in the back, thousands of friends, all of those touched by Justin, and his brothers and sisters in blue. We are a proud family. As his father, I can stand here today and say that we raised him right. Please don't think for a second that we're not sad. We think of Justin every minute, every hour of every day. In fact, I still reach for my phone on occasion to call him, hear his voice, to check on him. That's what a dad does. He was my son, my buddy, my right-hand man. We did scouts. We coached baseball, basketball, football, soccer. We fished, went to sporting events, everything a dad and a son could do. Justin was fun. Justin grew up watching me. At an early age, I could tell he wanted to follow in my footsteps and become a police officer. He, like many of you, was reminded daily of the consequences of bad choices. To think before you act, to work hard for what you want in life, and to achieve your goals. He did well in school, excelled in sports, and was very much liked. He graduated high school, went on to the University of Akron, and received his criminal justice degree. He worked at the Medina Juvenile Detention Center for a couple of years, where he took a huge interest in helping troubled youth. He took an interest in their stories and got a better understanding of how they got there. He always thought that someday he would be able to fix some of those problems. He learned something from everybody. While I was retiring, he again followed in my footsteps to further pursue his career in law enforcement. He attended the Summit County Sheriff's Academy, and while there was selected by the city of Akron to become a police officer. We knew he was on the right path and supported his endeavors. Justin then started the Akron Police Academy, and after completion became part of the Akron Police Department, where he worked trick 4, 7 at night to 3 in the morning. He and his partner Kevin fought crime on the busiest shift, the busiest, roughest part of town probably. Justin loved his job. He never gave up. He worked hard and continued to learn. I saw success in Justin. As he took on several interests in the police department, I knew that he had what it took to be a good cop, and I was very proud of him. His mother was also very proud of him, not only as a police officer, but as a concerned son who would be there for her daily as she battled stage 4 ovarian cancer. Justin helped her and remained by her side as she continued to battle for 2 more years. One of her biggest smiles, I can never forget, one of her biggest smiles came when Justin informed her that she was going to be a grandma for the first time. For the next several months, that's all she talked about was being a grandma. Unfortunately, on the night that we had the whole family at our house for Justin's birthday party, she passed away. She said that she did not want to plan Justin's birthday, waited until after the midnight hour to pass. Justin took her especially hard. Justin gave his daughter Lori's middle name, Ann. She never got to meet the beautiful child that Elise and Justin brought into this world. Charlie was Justin's world. A young father, great career, he was living. He and Elise raised their daughter, taught her right from wrong, and she continued to be the joys of our lives. Charlie learned about her grandma through Lori's pictures, conversation with us, and visits to the cemetery. Ironically, that's how she will have to learn from now on about her dad. She will learn he was a great guy, fun-loving, super dad. Justin became a pageant dad when Charlie was chosen as Little Princess in the Barberton Cherry Blossom Festival. Justin walked around at that stage, the big smile. Definitely a proud dad moment. Charlie loved to go fishing with her dad. They all loved camping in the outdoors. Justin was going to make a sportsman out of his little princess. Now, she will have to learn to do things without her dad. She couldn't invite him to her preschool class this year. The day they had donuts with Dad. All the other kids were there with their dads. I went in his place. I felt her pain. After we went to the cemetery to visit her dad, where he lays next to his mother. Together we talked, we prayed. She left him with a donut. That made her feel a little bit better. She had to start her first day of kindergarten without her dad. I went in his place, along with her mother and other family members and a host of 50 law enforcement officers from across the county. We knew this was no substitute for her father, but it was the least we could do. She went to school that day feeling a little bit better. I couldn't even imagine what the rest of Charlie's life would be like without her dad. But obviously she's going to miss several things that a daughter will look to her father to help her through. Charlie will face many challenges ahead without her dad. She is 5. I will be there. Her mother will raise her along with all the other support that has been offered because someone wanted to do something because Justin is no longer with us. Kelly, my daughter, Justin's sister will have to go through life without him. Justin was the big brother that gave her hugs when she needed them. He made her laugh when she was down. He was there for her and her family if he was ever needed. They were only 2 years apart. To me, that was the perfect age to raise two children. He was her rock. She relied on him in many ways, many things. He was always there for her. But now all of that has changed. Tiffany, the person who lost a whole future with a man that she adored. Recently engaged, we attended their party as they planned their future. Justin called me from the Bahamas the night they proposed and informed me that she said yes. They planned their home to include a room for Charlie. They made a great couple and lived as a family when Charlie came over. Charlie was making preparations for a stepmom. Sadly, a few months later, we went from planning their wedding to planning his funeral. Tiffany now goes home to a house that is quiet, lonely, and without Justin. My mother, Justin's grandmother, now in her 90s. Prays constantly that we all get through this somehow. She calls me nearly every day to check on us. She was proud of her law enforcement family. My father was also proud to see another Weinbriner in law enforcement. He instilled in us what his father instilled in him. My father, at nearly 90 years old, went to work that day, went out to dinner with my mother, and died of an aneurysm that evening. He was our foundation that Justin was built on. Justin left behind several relatives that will miss him, his warm heart, his charm, hundreds of friends that will miss his humor and smile. The brothers and sisters in blue that have come to be part of our family. To his latest patrol partner, also named Justin. They will have to pick up where 1301 is left off. For the Akron Police Department, great job on their investigation, the collection of evidence, the prosecutor's presentation, flawless. The jury's evaluation decisions, accepted. God was in our courtroom. In fact, his name was mentioned several times. Our laws are based on God's laws. Unfortunately, we're becoming a godless society. We as parents teach our kids to respect one another and respect our laws. Respectability, accountability, they're taught to us. Unfortunately, again, kids are not taught respect in the family. We'll show little respect for teachers and authority in the schools. Therefore, we'll have little or no respect for police and authority on the streets. This is what led us to where we are today. We need respect. We talked about good parenting. We're all born innocent. Parents need to not teach hate and prejudice. I pray for all the families involved in this tragedy, all of them. Akina, I hope that someday you accept accountability and responsibility for what happened. I heard, I'm sorry for what happened. In fact, I heard that from hundreds of people, including you. I heard that I hope God can see you through this. I heard that from a lot of people also, including you. I want you to know that you are responsible for ruining a good family. We will get back up. We will survive. We will move on. But you did a lot of damage.
The judge decides the suspect's fate, and the jury plays a crucial role. The jury carefully considered every point of argument made in court before determining Keenan's destiny.
The jury has indicated that they have a verdict. The court would like to indicate for the record that since Tuesday, October 13th at 1:57 p.m., the jury has been sequestered during the entire deliberations. This sequestering took place under the guidance of my bailiff, court staff, and Ruth Squires, a court employee, along with numerous sheriff's deputies. The court would like to thank those staff members and employees that volunteered to work those extra long hours. The jurors' hotel rooms were checked. They did not have television access, radio, or internet access. The entire floor of the hotel was sequestered, with the exception of the court staff or security who were present. The alternates have been kept sequestered, separate and apart from the 12 jurors while the jurors were deliberating. I'm now asking a question of all 12 jurors, and I'm just going to ask you to please answer this question yes or no as a group. Ladies and gentlemen of the jury, as a result of your deliberations, have you reached a verdict? Yes. And now our foreman, Mr. Persley, juror number 7, you've been selected as the foreman, is that correct?
Yes.
All right. I'm going to ask some questions of you now individually. Master Foreman, as a result of your deliberations, have you been able to reach verdicts in this case?
Yes, we have.
And have those verdicts that you've been able to reach been signed by all 12 of your members?
Yes, we have.
Also, you have been sequestered since you started your deliberations, is that correct?
That is correct.
To the best of your knowledge, has your jury been free from any influence outside of the jury room?
Yes.
And have only the 12 jurors actually participated in the deliberations, no alternates, is that correct?
That is correct.
All right, thank you. Can you please hand those verdict forms to my bailiff? I need to review them. All right, then, I'm just going to ask you a couple more questions as to this particular form. Similar to the ones I previously asked, Mr. Foreman, as a result of your deliberations, were you able to reach a verdict as to that specific specification form that I presented to you?
Yes, we were.
All right. And has that, if necessary, if it was necessary to be, has it been signed by all 12 of your members?
Yes, it has.
All right. And I'm going to ask you then to hand that. We already did, okay. So this is now the completed count 10 with the additional form filled out. I will note for the record that a couple of these verdict forms, let me indicate, some of them had originally had the date of the 14th, which would have been yesterday, filled out. And then I note that they're crossed out and the number 15 was written in, which would reflect today's date. And it's got the initials DP. I presume those are your initials, Mr. Persley?
Yes, they are.
All right. And so were you just correcting the date to reflect the fact that today is the day that you're formally rendering your verdict?
Yes, that is
okay.
the case.
So you may have signed these yesterday, but you wanted to reflect the correct date?
Yes.
All right, thank you. All right, at this point then, I'm going to hand these back to you. Ask the foreman and the defendant to please rise. And Master Foreman, speaking for the jury, I'm going to ask you to indicate what the verdicts are on each count. I'm going to go through them all with you and ask you to answer the questions as appropriate depending on the verdict, okay? So we will start with count 1, aggravated murder of Justin Weinbriner. I'm going to ask you, how do you find, and you just indicate we, the jury, either find guilty or not guilty as to the questions, okay? All right. As to count 1, aggravated murder of Justin Weinbriner, how does the jury find?
We find the defendant guilty.
As to specification 1 to count 1, asking the question whether this offense of aggravated murder was or was not part of a course of conduct involving the purposeful of or attempt to kill 2 or more persons, how does the jury find?
We find that it was.
As to specification 2 to count 1, asking the question of whether the defendant did or did not discharge a firearm at a peace officer, how does the jury find?
We find that he did.
As to specification 3, asking the question whether the defendant did or did not have a firearm on or about his person during the course of this offense, how did the jury find?
We find that he did.
As to count 2, Justin Weinbriner, how does the jury find?
Guilty.
As to specification to count 2, whether he did or did not discharge a firearm at a peace officer, how does the jury find?
We find that he did.
As to the specification 2 to count 2, whether the defendant had a firearm on or about his person during the course of this offense, how does the jury find?
We find that he did.
As to count 3, Justin Weinbriner, how does the jury find?
Guilty.
And as to the specification 1 to count 3, whether he did or did not discharge a firearm at a peace officer, how did the jury find?
We find that he did.
And specification 2 to count 3, while committing this, did he or did he not have a firearm on or about his person, how does the jury find?
We find that he did.
As to count 4, the felonious assault of Justin Weinbriner, how does the jury find?
Guilty.
As to the additional finding, whether Justin Weinbriner is a peace officer, how does the jury find?
We find that he is.
Okay. And then as to specification 1 to count 4, whether the defendant did or did not discharge a firearm at a peace officer, how does the jury find?
We find that he did.
As to specification 2 to count 4, whether the defendant had a firearm on or about his person, how does the jury find?
We find that he did.
As to count 5, the attempted murder of David Roccotti, how does the jury find?
Guilty.
And as to the specification, whether the defendant did or did not have a firearm on or about his person during such offense, how does the jury find?
We find that he did.
As to count 6, the attempted murder of David Eisel, how does the jury find?
Guilty.
As to specification 1 to count 6, whether he did or did not have a firearm on or about his person, how does the jury find?
We find that he did.
Count 7, felonious assault of David Roccotti, how does the jury find?
Guilty.
As to the specification whether he did or did not have a firearm on or about his person, how does the jury find?
That he did.
Count 8, felonious assault of Jennifer Imhoff, how does the jury find?
Guilty.
As to specification 1 to count 8, whether he did or did not have a firearm on or about his person during said felonious assault, how does the jury find?
That he did.
As to count 9, the felonious assault of Michael Capes, how does the jury find?
Guilty.
As to specification 1 to count 9, whether he did or did not have a firearm on or about his person during said felonious assault, how does the jury find?
That he did.
Count 10, the felonious assault of Thomas Russell, how does the jury find?
Guilty.
As to the additional finding about whether Thomas Russell is or is not a peace officer, how did the jury find?
That he is.
Specification 1 to count 10, whether the defendant did or did not discharge a firearm at a peace officer while committing the felonious assault, how does the jury find?
That he did.
Specification 2 to count 10, whether the defendant did or did not have a firearm on or about his person during said felonious assault, how does the jury find?
That he did.
And count 11 is the felonious assault of David Eisel, how does the jury find?
Guilty.
As to specification 1, whether the defendant did or did not have a firearm on or about his person during said felonious assault, how does the jury find?
That he did.
Count 12 is having a weapon while under disability, how does the jury find?
Guilty.
Count 13 is carrying concealed weapon, how does the jury find?
Guilty.
Count 14, illegal possession of a firearm in a liquor permit premises, how does the jury find?
Guilty.
Count 15 is the tampering with evidence charge, how does the jury find?
Not guilty.
All right. Thank you. I'm going to ask you to pass those verdict forms back to me. And I'm going to ask counsel to meet me at sidebar with the court reporter.
When a judge issues a sentence regarding a suspect, they consistently strive to ensure that the sentence is reasonable in light of the crime the suspect committed and fair to the victim. This judge acted in the same manner.
Well, Mr. Ivory, you know you've been tried and convicted by a jury of aggravated and numerous other charges, including the attempted murder and felonious assault of others. You do have the right to appeal your convictions. If you cannot afford an attorney, one will be appointed for you. This appeal must be filed within 30 days of the date of the filing of your sentencing journal entry. The court finds you to be indigent based upon your personal present circumstances, and I will appoint an experienced appellate lawyer for you. That lawyer would be different from your defense counsel. That lawyer will review your case and handle the appeal as is the normal procedure, that we put someone different to review the case. That is if you wish to appeal. Do you wish to appeal your convictions, and if so, do you wish the court to appoint a lawyer for you?
Yes.
You will be given credit for all the Summit and Medina County jail time that you have served in this case, which according to the court's calculations, and I will double check that number, but I believe it to be 346 days. You will pay the costs of this action. Even though you are indigent, I am aware that while incarcerated, you will be paid a small stipend from the state of Ohio. I hereby enter judgment as to all costs owed in this matter, excluding attorney's fees, but I will order that those costs are not to be collected at a rate greater than $5 per month until satisfied. I do have to notify you of the issue of post-release control as to the charges other than the aggravated, so I'm going to do that now. As to the felonies of the first degree, which are the attempt charges and the felonious assault of a police officer, there is something called post-release control that if you were ever to be released, and I realize in light of your sentence that this may seem to be nonsensical, but the court is required to give this instruction. If you were to ever be released, you would serve 5 years of mandatory post-release control on those charges. As to the felonious assault charge, you would face this, that are the felony of the second degree, you would face 3 years of mandatory post-release control. As to the weapon under disability charge and the illegal possession of a firearm in a liquor permit premises, you would serve 3 years of mandatory post-release control. And as to the carrying concealed weapon charge, you would serve 3 years of optional post-release control. The optional post-release control issue is determined by the Ohio Department of Corrections. If all of that were to somehow happen, which obviously doesn't seem likely, the court has to instruct you that if you were to be released and you were to violate any post-release control that you were to be placed on, you could potentially be sanctioned and have to return to prison and serve up to half of your sentences on those different charges as a part of that sanction. Do you understand that issue?
Yes.
All right. Well, the court has heard all of the evidence presented in this trial. I find that consecutive sentences are necessary in this case to properly punish you, the offender. You killed someone and you wounded numerous others. Consecutive sentences are not disproportionate to the seriousness of your conduct and to the danger you pose to the public. Your supposed provocation for this crime was non-existent and brought on by your own cowardice, ego, and sense of self-importance. For such a violent act to occur with no warning, after no provocation, save being asked to leave a private establishment, shows the danger that you could pose to society if you would ever go free. I also particularly find, pursuant to Revised Code Section 2929.14CB, that at least 2 of these offenses were committed as part of a course of conduct, and the harm caused by 2 or more of these multiple offenses was so great and unusual that no single prison term for any of the offenses committed as part of this course of conduct adequately reflects the seriousness of your actions. In addition, Part C of that same subsection of statute applies, as I find that your history of past criminal conduct in the trade of drug dealing and your past conviction for possession of a firearm in violation of the law demonstrates that consecutive sentences are necessary to protect the public from future crime by you. The victims in this case are many, Mr. Ivory, and I'm just talking about the people that were in the bar that night. Dave Wolcady, who you had the misfortune to encounter when you returned to the bar. Mr. Wolcady knew that you'd been kicked out. Prior to your returning, I don't believe he ever said a word to you. At least I didn't observe that on the video. During your trial testimony, much was said by you of the supposed threat and fear that you felt in encountering Mr. Wolcady. Yet other than using harsh language to tell you to leave, Mr. Wolcady never laid a hand on you. If anything, he blocked your path and slowed you down. But he didn't stop you. Ultimately, You chose to walk around him. He took a bullet in the abdomen and clearly almost died because of you. Yet you claimed you were the one in fear. The court does not believe that. Miss Imhoff, having a good time, minding her own business, and yet she walked through the arm, and also to her horror, saw her friend Dave fallen on the ground everywhere. Mr. Russell, another off-duty police officer just sitting at the bar who had no idea what was happening, but felt the sting of the bullet as it passed by him, miraculously missing him. Officer Russell then went outside and saw his fellow officer lying on the ground in mortal danger. And he was able to have enough presence of mind to pull out his badge and start organizing the chaos, preserving witnesses for the investigators. I'm sure the sight of his fellow officer down on the ground still haunts him. Mr. Capes sent me a letter. He did not wish to have it read out loud. How eerie it was to watch the video and see Mr. Capes and his girlfriend enter the bar mere seconds before the shooting. And instantly is hit in the foot and cannot walk or move. Not fully healed 11 months later, we saw him limp as he walked up to this jury, or to this witness box to testify. David Eisel, we saw the hole that ripped through his windbreaker, right over his heart, miraculously not hitting his body as he threw himself into the path of that, along with Justin Weinbriner. So someone must have plans for Mr. Wolcady, Miss Imhoff, Mr. Capes, Officer Russell, and Mr. Eisel, because they had a brush with death that night and each was spared. One was not. You ripped a man away from this society and you took a devoted son and brother, a proud and caring father, a loving husband-to-be, a loyal friend, a proud public servant, and a police officer. And by all accounts, a great police officer. I have been part of the justice system for many years, 28 to be exact. I have been involved in my fair share of cases as an attorney and as a judge. These cases bear many similarities: a wrongful act, the loss of a loved one, and 2 grieving families. While not personally involved or acquainted with either of these families, aside from this case, I can tell you, I feel their grief. I can see and feel the grief of the Weinbriner family. Likewise, I feel the grief of your family. No one talks much about the offender's family, but I want them to know I see their grief too. I heard it in the mitigation hearing. I'm sure Justin's family did too. But this case is different. And it is not different for me for the reason you might think. It is not different because Justin Weinbriner was Akron police officer Justin Weinbriner. It is different because of the way in which Justin. I am sure that the values taught to Justin in the police department about sacrifice and service came into play that night. Justin's training was ignited, and the desire to protect others overtook him, I am sure. His is a death the likes of which I have never seen in all my 28 years of working in our justice system. While the homicidal act that you committed was senseless, Justin's death was not. It was sacrificial. Justin laid down his life for his friends. And there is no greater act of love than this. Justin saved lives, and it needs to be said, David Eisel, you saved lives too. For doing this, Justin paid the highest price, but based on everything I have learned and heard about him, there's no question that if he were put in the exact same situation again, he would not hesitate. He would do it again. Mr. Ivory, you have made many mistakes in your life, but you have done some good things. You've also been given many chances. I'm aware of the full nature of those chances. I run a reentry court, and I know you were in one. You have the support of a loving family, and by all accounts, 2 wonderful sons. So much to live for. but you didn't appreciate it. You chose to let a petty disagreement brought on by your own behavior ruin your future. You wreaked havoc and chaos when you marched back into that bar, believing yourself to be insulted and disrespected. What a woefully tragic decision you made that night. Tragic for Justin and tragic for your family. And while you stand here still drawing breath, justice demands that you never again breathe air as a free man. You will never again walk among us as a free man. You will spend your days and nights surrounded by countless other prisoners bound by the fateful choices they have made in their lives. You will die in prison. And while you may be feeling sorry for yourself, remember, you can write to and call and speak with your family. Justin's daughter, Charlie, will never hear her daddy speak to her again. You can make friends and smile and talk and socialize. Justin's smiles and hugs, which we all witnessed him give to others as he entered Papa Don's that night on the video, they are no more. You will be guarded and protected by others, 24 hours a day, 7 days a week. But Justin guards and protects no more. You will have a life. Justice is gone from this earth. So for your actions, this court pronounces the following sentence, which you fully deserve. I am bound by the recommendation of the jury. Legally, the court must impose a sentence of life without parole as to count 1, the aggravated murder of Justin Weinbriner. As to the firearm specification in count 2, the court imposes a 7-year sentence which will run consecutively. Counts 2, 3, and 4, the court is not sentencing on those as the state has elected that they merge and is proceeding only on count 1. As to count 5, the attempted murder of David Wilcady, I'm imposing an 11-year sentence plus 3 years for the firearm specification to run consecutively to the aggravated murder charge. I am imposing, as to the attempted murder of David Eisel, an 8-year sentence plus 3 years on the firearm specification for an additional 11 years to run consecutive to all other counts. As to count 8, the felonious assault of Jennifer Imhoff, I am imposing a 7-year sentence plus 3 years for the specification for a total of 10 additional years to be run consecutively. For the felonious assault of Michael Capes, I'm imposing a 7-year sentence plus 3 years for a total of 10 years to run consecutively. For the felonious assault of Thomas Russell, I'm imposing a 3-year sentence plus 7 years for the specification for and a peace officer for an additional 10 years to run consecutively. I find that the other firearm specification in that count merges. And as to count 12, the having a weapon while under disability, a felony of the 3rd degree, I am imposing a 3-year sentence, which I am running consecutively to all other counts. And counts 13 and 14 I find merge, and count 15 is the count that you were found not guilty of by the jury. That is a final sentence of life without parole plus 65 years. We are concluded.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.